Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're beginning a brand new 4-part series entitled Update on the QME Regulations. And over the next 4 weeks, I want to share with you some of the important labor codes and California codes of regulation that directly relate to the work that we do. And I wonder how many of you have this book. How many of you have this book? This is the 2015 edition of the Workers' Compensation Laws of California. If you don't have this book, maybe you have an earlier edition, but I wonder how many of you have some edition of this book. This is published by LexisNexis. Well, look at the size of this book. This book is approximately 3 to 4 inches thick, and it has 1,875 pages, all relating to workers' compensation laws in California. So that's interesting and that's amazing, but of the entire 1,875 pages contained within this book, how many of those pages, how many of those codes, how many of those regulations directly applied to the work that we do as qualified medical evaluators? Well, it's a small fraction of that, let me tell you. And that's good news for us, because we don't have to know every single law that governs the practice and regulation of workers' compensation in California. But we do need to know the regulations that apply to the work that we do as qualified medical evaluators. And for those of you that know me, you know we've either spoken on the phone or communicated by email. I spend quite a bit of time talking and consulting with doctors, and almost universally I find that most doctors, after they receive their QME credential and they've passed the competency examination to obtain their QME credential, they all immediately forget all of the labor codes and regulations that they learned and that they had to demonstrate understanding of in order to get their QME credential. And I'm the same way. You know, they say if you don't use it, you lose it. Well, I find that many doctors, because they've forgotten these important codes and important regulations, they fail to fashion their physical examination, they fail to fashion their face-to-face evaluation, and they fail to fashion their subsequent QME reports in accordance with the regulations and labor codes that govern the work that we do. And so many doctors are producing a work product that does not comply with guidelines and does not comply with requirements. And I'm not even talking about the AMA guides here. I'm simply talking about what do the labor codes and the California codes of regulation require of us as qualified medical evaluators as minimum standards in performing the work that we do. And in the course of some of the consulting work that I do, I have the opportunity to review many doctors' QME reports. And it's quite an interesting process to review another doctor's QME reports, because you can see where there are errors and where there are omissions and where there are misunderstandings regarding the codes and regarding the regulations. So what I want to do over the next 4 weeks is I want to share with you and review with you some of the critical codes and some of the rigorous regulations that govern the work that we do, so that we're all on the same page, so that we're all refamiliarized, and so that we all hear these codes and hear these regulations with new ears, so that we can move forward together as a group producing a better work product. That's the whole purpose of this 4-week series, is to help us to produce a better product more in compliance with codes and regulations. And I don't know if you're aware of this or not, but there's a whole new staff down at the Division of Workers' Compensation Medical Unit who have as their sole purpose reviewing doctors' work products, reviewing our reports to make sure that our reports do indeed comply with all the regulations and all the labor codes that govern the work that we do. So my purpose in presenting this series over the next 4 weeks is twofold. Number one is I want to review the codes and regulations so that we can all move forward as qualified medical evaluators and practice in a manner that's safe, so that we stay out of scrutiny's watch, and we stay out of the eye of oversight and disciplinary committees. So that's my first purpose, is to make sure that we're performing our work in a way that we're supposed to, so that we are able to continue and enjoy a long, happy career as a qualified medical evaluator. So that's my first purpose. But my overriding purpose and my main purpose, and the theme that I want to share with you throughout the next 4 weeks, is I want us to all come up to speed on the labor codes and regulations so that we can use those labor codes and use those regulations to our benefit. So it's one thing to present this material to you in such a way that scares you and makes you afraid that you're going to be subject to disciplinary action. But rather, what I'd prefer to do is I'd prefer to look at these labor codes and look at these regulations and look for the kernel, the critical kernel within these codes that serve us as the qualified medical evaluators. And guess what? Those kernels are in there, and I'm going to share those kernels with you. So the theory and the premise of the next 4 weeks is that the codes serve us. They're there for a reason. They're there to help us create a better work product, to do a better face-to-face evaluation, to do a better physical examination, and to produce QME reports that are better, that are clearer, that are more accurate, that comply with timeline requirements, that contain all the necessary disclosures. Why is it important to contain the disclosures? Because it's important that we comply with the disclosures. The disclosures are there not to scare us. They're there to help us and guide us as we go about the work that we do. So over the next 4 weeks, I'm going to be showing you the critical codes that govern the work that we do, and I'm going to show you how these codes are designed and intended to serve us to become better evaluators. So beginning today, in week 1 of this series, we're going to have a game show quiz, a game show quiz, and we're going to test and review your knowledge on some of the labor codes that govern the QME panel process. And we're going to keep that fun, and we're going to keep that light, and we're going to find out how much you know and how much you actually remember about the QME panel process. And this is going to be tremendously enlightening for you, because I'm going to reveal for you some facts, facets, and factors about the labor codes that govern the QME panel process to show you how those facts, factors, and facets benefit you, how they help you construct your exam in such a way that produces a better QME report. So that's what we're going to do today. And then next week we're going to go over the codes and regulations that govern the face-to-face evaluation. And then over the next 2 weeks after that, meaning in week 3 and week 4, we're going to review the QME regulations and labor codes that govern our QME reports. And that's going to take 2 complete weeks to handle all of those important codes and regulations. So I guarantee you that by the end of this 4 weeks, you're going to be a better qualified medical evaluator, both in the face-to-face evaluation, and also you're going to be a better evaluator who produces QME reports that are more substantial, that are more credible, that are more persuasive, and that basically are irrefutable as substantial medical evidence. So I encourage you to stay tuned through each and every one of these sessions over the next 4 weeks. By the end of the next 4 weeks, you're going to be a totally different evaluator. So let's begin our workshop today by going down to the computer. And on the computer, we're going to have a game show where we review and test your knowledge on the QME panel process. So I look forward to being back with you in a couple minutes. as we begin part 1 of our new 4-part series on the QME regulations. Hi, this is Dr. Perry Carpenter. Thanks for joining me for the game show quiz on QME regulations. And of all the QME regulations and labor codes that describe and define the type of work that we do, several of them are critical. It seems that the 80-20 rule applies to QME codes and regulations. About 20% of all the codes and regulations have about 80% of immediate application to our day-to-day evaluations and face-to-face meetings with injured workers. And I want to review several of those codes with you today. I want to review the following codes. I want to review Labor Code 4060, 4061, 4062, and then Labor Code 139.2, and then finally Labor Code 4628. And I'm going to test your knowledge on these labor codes in a game show format. So let's have some fun with this material and see how well you do on these very common and daily used QME codes and regulations. Okay, here we have our game board, and you can see that I have the labor codes here across the top of the screen. We have Labor Code 4060, 4061, 4062, 139.2, and 4628. And for this discussion, let's concentrate on Labor Code 4060 and test our knowledge and remembrance of this important labor code. So for 10 points, please answer the following question. This labor code, is this true or false? And this refers to Labor Code 4060. This labor code deals with the appointment and reappointment of QMEs. Is that true or is that false? We're talking here about Labor Code 4060. Is that true or is that false? Well, let's see. That is false. That is false. This labor code deals with the QME evaluation process when the dispute involves the compensability of an injury. So doctors, many of the evaluations that you are getting are evaluations that are being ordered under Labor Code 4060. And we'll talk a little bit more about how you can identify and determine that indeed the evaluation that you're performing is an evaluation that's being ordered under this particular labor code. Okay? So the answer to that question is false. We're dealing about disputes here over compensability of an injury. Okay? Labor Code 4060 for 20 points. Okay? Question. If you have an examinee who requests a QME evaluation for a date of injury 15 months ago, it is likely that you are performing an evaluation under Labor Code 4060. So let's make this real. Let's say, for example, today's date is January 1st, 2016, and the date of injury for your examinee is September 1st, 2014, approximately 15 months ago. And I'm just using the number 15 months ago to indicate that there's considerable time gap between the date of injury and the date of your evaluation. In this case, we're talking about a time gap of 15 months. Could be 18 months, could be 12 months, could be 24 months, etc. But there's a substantial gap. Okay? So if you have an examinee with a substantial gap between the date of injury and the date of your evaluation, it's likely that you're performing an evaluation under LC 4060. Is that true or is that false? Well, that would be false because for a Labor Code 4060 evaluation, it's more likely that you'll be evaluating the examinee much closer to the date of injury, such as within 90 days. And we know that because Labor Code 4060 evaluations are evaluations that are ordered for the purpose of resolving a dispute over the compensability of an injury. In other words, whether or not an actual industrial injury occurred for which the claims administrator is responsible. So typically what will happen is an employee will fill out a claim form for either a specific or a cumulative injury. And if the claims administrator either denies liability for that injury or delays a determination of the liability for that injury, this is when you would be called in to perform an evaluation under Labor Code 4060. Now, other regulations tell us that after 90 days, if there's no determination made after 90 days, the industrial injury is presumed to be compensable. So for the most part, Labor Code 4060 evaluations are evaluations that take place much closer to the date of injury than some of the evaluations that we're more accustomed to. Okay, next question for 3 points. Under Labor Code 4060, is it true or false that both the employer and the employee can both request a comprehensive medical evaluation? So let's go back to our scenario. Let's say an employee fills out a claim form for a specific injury, let's say to the lumbar spine. And the employer denies liability for that injury. In this case, which of the parties, the employer or the employee, has the authority to request a comprehensive medical evaluation? Is it the employee? Is it the employer? Or is it both? Well, it is. It's both. Either party, and this is part of the text of Labor Code 4060, either party may request the evaluation to either prove or disprove the compensability of the injury. So the employee would order the evaluation in the hopes of proving that indeed an industrial injury did occur, whereas the employer would order the evaluation hopefully from their perspective to disprove that an industrial injury took place. Okay? So important point here is that either party can request the evaluation. Okay, Labor Code 4064. Okay, question. If there is a dispute over the compensability of an injury and the employee is unrepresented, we then refer to Labor Code 4062.1 for instruction on requesting a QME panel. So let's clarify this. Here we are. We're in Labor Code 4060, and we're talking about how disputes over compensability are resolved. Well, in the case of an unrepresented injured worker, what code then do we refer to as to how an unrepresented injured worker should proceed to request such a panel? Is that Labor Code 4062.1, or is that some other panel? Or is that some other code? True, it is 4062.1, which is the universal code that describes how QME panels are requested for unrepresented injured workers. So as we're going to see, there are several labor codes that dictate the type of evaluation we're performing. And we're talking right now about evaluations that are ordered under Labor Code 4060 to determine the compensability of a claim. Well, there are other disputes besides compensability that we as qualified medical evaluators are called upon to resolve, and those examinations are ordered under different labor codes. But regardless of the labor code that dictates the type of evaluation that we're performing, we refer universally to Labor Code 4062.1 to tell us how the process unfolds and evolves when we're dealing with unrepresented injured workers. And as we're going to see, it's going to be a different code that we refer to when we are involved with represented injured workers. Okay, so how are you doing so far? Hopefully you have more questions correct than incorrect. Okay, next question. Finally, Labor Code 4060 for 50 points. Okay, next question. If there is a dispute over compensability and the employee obtains an independent evaluator and the independent evaluator opines for an industrial injury, then the employer is responsible for the cost of the evaluation. This is to be contrasted with the situation where the independent evaluator opines against an industrial injury. So in this case, we have an employee who's claiming an industrial injury. The employer disputes that indeed an industrial injury took place, and the employee then obtains an independent evaluator. The independent evaluator reviews all the facts, performs a physical examination, and in the opinion of the independent evaluator, there indeed was an industrial injury. In other words, the employee did indeed suffer an industrial injury. In that case, is the employer then responsible for the cost of the evaluation? True or false? Well, that would be false, because independent evaluators and charges for independent evaluations shall not be borne by the claims administrator, nor shall they be borne by the employee. So Labor Code 4060B gives us instruction on this. It says that neither the employer nor the employee shall be liable for any evaluation from any evaluator, except if that evaluation is performed by the primary treating physician, except as provided in this section, which is section 4060. However, the reports of treating physicians shall be admissible. So what this is telling us is that in cases of disputes are resolved in a very specific manner. They're resolved in the panel QME process, not through the use of independent evaluators on the side of either the employee or on the side of the employer. So if the employee takes it upon themselves to go out and obtain some sort of an independent evaluation, the employer is not responsible for that, because the obtaining of that independent evaluation did not follow the process and procedure as described in Labor Code 4060. So in that event, no medical evaluator should perform an evaluation outside of the process described in Labor Code 4060, because there's a good chance that nobody's going to pay them. Certainly the employer is not going to pay for that evaluation. Okay, so that is Labor Code 4060. Let's review Labor Code 4060 now in its entirety. Okay, so here it is, 4060. It says that this section shall apply to disputes over the compensability of any injury. And perhaps in this case, we should underline or highlight, but let me just indicate here that Labor Code 4060 is the one that we refer to when the dispute is over the compensability of an injury. And we're going to see that we have other labor codes to deal with disputes of permanent impairment, disputes over apportionment, disputes over future medical care, and all other medical issues. But when the dispute involves compensability, it's Labor Code Section 4060 that we refer to. It says this section shall not apply where injury to any part or parts of the body has been accepted as compensable by the employer. So that makes sense. This section only applies to unresolved disputes over compensability. Neither the employer nor the employee shall be liable for any comprehensive medical legal evaluation performed by other than the treating physician. However, treating physician's reports shall be admissible as evidence to resolve such a dispute. If a medical evaluation is required to determine compensability at any time after the filing of the claim form and the employee is represented by an attorney, a medical evaluation to determine compensability shall be obtained only by the procedure provided in Section 4062.2. And we didn't talk about those cases where the employee is a represented employee. We focused so far our discussion on those employees that are unrepresented. But in the case of a represented employee, we refer to Section 4062.2. And for unrepresented employees, we refer to Section 4062.1. If a medical evaluation is required to determine compensability at any time after the claim form is filed and the employee is not represented by an attorney, the employer shall provide the employee with a notice, and this is a letter in the mail. And the notice should say either, number one, that the employer requests a comprehensive medical evaluation to determine compensability, or number two, that the employer has not accepted liability, and then therefore the employee may request a comprehensive medical evaluation, again to determine the compensability. Either party may request a comprehensive medical evaluation to determine compensability. The evaluation shall be obtained only by the procedure provided in Section 4062.1, which is the section that deals with unrepresented injured workers. Okay, doctor, so let's review Labor Code 4060. Now, you're going to be getting evaluations that are being ordered under Labor Code 4060. And when either the employer or the employee orders a QME panel under Labor Code 4060, the form that they use to order these panel evaluations, or the panel QMEs, the list of panel QMEs, there's a checkbox to indicate under which labor code the request is being made. Now, Labor Code 4060 evaluations have one singular purpose, and the singular purpose of them is to determine whether or not there's a compensable injury or not. So these are the type of evaluations that will typically be performed reasonably proximate in time to the reported date of the injury. If you're receiving a request for a report and the examinee has already received medical treatment, has already been declared to be permanent and stationary, then that's not an evaluation that you're going to be performing under 4060. So a Labor Code 4060 evaluation is a different type of evaluation than an evaluation that's performed under a different code that may involve a different type of dispute. Say, for example, a dispute over permanent impairment. It's a different type of report. So for a compensability evaluation under Labor Code 4060, there's good likelihood, not all likelihood, but good likelihood that you probably won't be addressing issues such as permanent impairment, such as apportionment, such as need for future medical care. More likely, you're going to be discussing issues such as causation, meaning AOE, COE, the injury arose out of and occurred in the course of employment. And you'll probably be talking about issues related to a current diagnosis and a current need for medical care. So it's important for you to determine what type of evaluation that you're seeing, so that you can fashion your interview, you can fashion your physical examination procedures, and really fashion all of your procedures in accordance with that type of an evaluation. So again, for 40/60 evaluations, you probably won't be addressing permanent impairment, and there's a good chance that the examinee's probably not yet permanent and stationary. Now, it's possible that they could be permanent and stationary if 90 days after the date of a reported injury, the examinee, with time and rest and the natural healing process, could be permanent and stationary. But it's probably more likely that under 40/60, if you have this evaluation, you're probably going to be recommending medical care, recommending a series of specialists, perhaps recommending diagnostic studies. And this is a type of examinee who's just going to be getting started on their workers' compensation claim. Other types of examinations that we do involve examinees who are at the end of their claim. They're concluding their claim. They're closing their claim, and they need a different series of opinions. And those are ordered under different labor codes. Those are ordered under labor codes 4061 and 4062. So look forward to being back with you tomorrow as we go into labor codes 4061 and 4062. And hope you got some new understanding about the uses and applications of Labor Code 4060 as it relates to the types of evaluations and the types of procedures that we employ in these evaluations. So this is Dr. Perry Carpenter. I look forward to being with you again tomorrow as we continue our current series on QME regulations. And tomorrow we continue with part 2 of our game show quiz.